Hi there, this is Attorney Andrew Marcantel with the Attorneys for Freedom. I'm a criminal defense attorney, I do civil rights as well, and I'm a partner here at the Attorneys for Freedom. Times of civil unrest like the ones that we're currently in mean very busy times for somebody in my profession. And we've been getting a lot of questions surrounding lots of different current events that are going on. There's rioting in the streets in many places of the country. And gun ownership is actually on the rise right now because people are interested in defending themselves in response to all of the craziness that's going on in the world. So I wanted to take some time today to address a question that we've been getting a lot lately that has to do with self-defense of property and family and home. A recent email submission from an attorney on retainer client gave us this question. I just wanted to read the question and address it as much as I can for you guys today. So here's what the question says. Quote, with this country's propensity to burn and destroy everything in sight when we are unhappy, my question centers around Arizona's self-defense laws with regard to civil unrest. I have lived through both the Watts and Rodney King riots, and I know it is extremely unlikely that I would ever have a problem in my part of town, but what would be the proper course of action if characters such as these ever laid siege to outlying neighborhoods like mine? Example, I'm standing on my property. A large group of unfriendly protesters on my street are facing me and my elderly neighbors with apparent intent on looting and destroying. I'm armed and I have issued warnings to the crowd. I understand the issue of shooting to defend property is usually a bad idea, but the question is, what level of physical violence, if any, would I have to absorb before I can act in self-defense? What actions on their part would or would not justify the use of lethal force? How would the courts interpret actions on their part, such as rock or brick throwing or use of Molotov cocktails against my property, such as my home, mass vandalism of my home, etc.? Does Arizona law address this? And what would you advise if presented with a situation like I have described here? So I think this is a fantastic question and a very common question right now. As you can imagine, we've been getting lots of similar questions from lots of people. So let me try to give kind of an analysis here. I think a good way to start this conversation would be to start with a real world example that is making headlines right now, right? We have the McCloskeys, who are the couple in St. Louis who allegedly waved and pointed guns at protesters in front of their house. And there's some video that has gone viral that surfaced on the internet. So let's start with this. We have a couple. We have videos of them taken by some of the protesters, of them holding guns, maybe even pointing guns, and yelling things back and forth to the protesters. So the first thing I need to know, I need some pieces of information to give a full analysis of this that perhaps aren't particularly clear at the time that I'm making this video. They may come out, the details may come out and be more clear in the coming days or weeks. But as of right now, at least, it's still under debate exactly what the nature of this protest was, and most importantly, how it entered that neighborhood in the first place. There are some people saying this was a straight-up break-in, a knocking down of a gate of a private gated-in residential community, and this was an unruly mob of people that were kind of storming in. Others on this point say, no, these people went through an open gate, it was public property, they stayed on the sidewalk, which is considered public property. This was not a private area that they were at. So obviously that the nature of their entrance into the community or property that they were in is a huge factor, and we'll return to that in a second. Another giant factor that's under dispute is the McCloskeys are claiming that multiple people in the group of protesters were making active threats to them, threatening to enter their property, threatening to burn down their property, threatening to throw bricks into their windows, and so on. So basically actively threatening a trespass. While other sources say, no, there was there was a little talking back and forth and insults hurled and everything, but nothing that the protesters said rose to the level of active threats. I think the videos that are currently going viral and surfacing right now don't really answer definitively either one of these important questions, at least not the ones I've seen. But for all we know, there could be some more videos that come out, more evidence that comes out. But as of the day of this, making this video, I don't know the answers to either of those questions. But I'll analyze the situation like this. I'll say, well, if it turns out that they had broken into the neighborhood, and if it turns out that they were making active threats and threatening a trespass, part of the question that we received here is, how much of this do I have to take? How much of their threats to injure me or harm my property do I have to take before I can act? It's a complicated question, especially under Arizona law where there's some certain nuances. So before I kind of dive into the question here, let's start with some ground rules, some basic Arizona bright line rules that we need to kind of work around while we're analyzing this question legally. The first is this, and it was alluded to in the question that I read from the AOR client. Property. Can I ever use deadly physical force to defend property? And there is a bright line Arizona rule that says you may never use deadly physical force if it's just to defend property. Okay, that's an important distinction there. If it's just to defend property, then you may never use deadly physical force. So let's return to the situation here. Well, if the protesters are throwing Molotov cocktails or bricks through windows or threatening, an imminent trespass, well, then it's no longer just a threat to property. I believe at that point, if the situation was thus that they were actively threatening such violent acts, I think that you absolutely are allowed at that point to at least make a defensive display in order to repel an imminent trespass. In fact, Arizona, and this isn't true of all states, Arizona has a few special statutes that may apply here. I mean, of course, they have their usual run-of-the-mill type self-defense statutes, like all states do, which say that you're allowed to use or display a proportionate amount of force such that it is reasonably necessary to stop an imminent trespass. We have those. Every state has self-defense laws. But Arizona goes a little bit further in its statutory justifications of use or display of force. One of them is you're allowed to display deadly physical force, display it, if it is to stop an imminent criminal trespass, in other words, or ongoing criminal trespass, and terminate that trespass. In other words, exactly what the McCloskeys are alleging that these people did. Now, keep in mind, when I'm talking about the McCloskey situation, they're in a different state. So the Arizona law that I'm describing is not going to apply to them. But the questioner, the AOR client, is asking about what if the same type of situation were to happen in Arizona. And Arizona does have a statute that says you are allowed to display deadly physical force in order to terminate a trespass that's currently in progress or to stop one that's imminent, right? That's reasonably imminent. And if you can show evidence that these people were threatening to enter the property and burn down the property with Molotov cocktails and toss bricks through windows which could hit people inside, they're threatening serious physical violence to these people, I think the answer is yes. Under Arizona law, you are absolutely entitled to at least display the physical force. You may not be entitled to discharge your firearm at that point just yet, but I think the display under Arizona law would in fact be justified. Now keep in mind too, there's another statute in Arizona, and that's Arizona 13-411. Okay, and what that statute says, it says that you're allowed to use deadly physical force to stop one of the following crimes from happening. And then it has a list of extremely serious crimes, ranging from homicide crimes to sexual assaults, kidnappings, and armed robberies, things like that. And it lists those and says you're allowed to display and even use deadly physical force to stop one of those things from happening. Well, among those is aggravated assault. And so if people are threatening to throw, use dangerous instruments such as Molotov cocktails and bricks to injure you or your family, then certainly 411, ARS 13-411 could potentially apply. The problem with that statute, practically speaking, is that a prosecutor can always argue, well, hold on, it wasn't imminent yet, right? It was just verbal. It was just verbal at that point, so it wasn't really imminent. It's a tougher statute to establish than something like a self-defense statute or the aforementioned anti-trespassing statute. But another important bright line Arizona rule is you do not have to wait till somebody's fist actually hits your face in order to defend yourself, right? You don't have to sit there and wait till they actually do the major transgression, till the bullet actually hits you, till the Molotov cocktail actually flies through your family's residence. You do not have to wait until it gets that far, until the force is actually used to either display or to use physical force. It's all going to be a question of what were your actions reasonable under the circumstances. Okay, so when somebody asks me, Andy, am I allowed to do this? If I were to do action X in this situation, would it be legal or illegal? What you're really asking me is, hey Andy, what I want you to do is predict for me, with this information that I've given you, what a randomly assembled jury of my peers in my jurisdiction would think is reasonable. Would that randomly assembled jury of my peers believe that my conduct was reasonable or unreasonable? Because almost all of the gun crimes in Arizona law and in most states use this term of reasonableness for the justification defenses, right? Was the amount of force displayed or used a reasonable and proportionate amount of force to the force that you were faced? Now, for the reasons that I gave earlier, I would argue that in a situation like we've been discussing, yes, there are strong defenses and the conduct was reasonable. But keep in mind, you never know what you're going to get in a jury, right? You can imagine that drawn from the same population, especially in Arizona, which is largely considered by many to be a purple state, consisting of a lot of right-wing and a lot of left-wing ideologies, depending on the jurisdiction and county and so on. You could imagine that we could get certain jurors in your randomly assembled jury pool that are friendlier to firearms and those that are more hostile to firearms. As somebody who has done many voir dires, that's the process prior to swearing in a jury, where we whittle down a jury pool down to the 12 that are actually going to decide the case, we get to ask them questions as part of this process. And I will always ask questions such as, well, who believes that for example, no private citizens should be able to own firearms? And inevitably, I get a couple of hands that say, yeah, you know what, I think only police officers should really be able to use firearms and everything. And then I use my preliminary strikes to strike that person so that they're no longer a chance of being on the jury. But we go back and forth between the state. You know, the state is striking people. If I'm defending somebody with a gun crime, the state may be striking people whose answers indicate a love for firearms or being pro-Second Amendment or something like that. The state will be striking those. I'll be striking the people who are strongly anti-gun. And then we typically end up with the 12 people who said the least during the voir dire, during the questioning. In other words, the people who we know the least about at that point. And you never really know what you're going to end up with when you're putting it in front of a jury. So keep that in mind, that if you are going to use or display a firearm, absolutely you should do so. If you are trained to do so, you're competent with the weapon, and you believe that your life is reasonably, or the lives of your family members or property, to some degree, if damaging the property would cause a safety hazard, such as lighting your house on fire with a Molotov cocktail, well, then you're not merely defending property anymore, right? And you should defensively display or use your deadly physical force of the firearm if it is reasonably in proportionate with the force, with the force that you're facing. So, to kind of address other parts of this question, it mentions neighbors. What if I have elderly neighbors and I'm concerned about that this angry, unruly mob is going to go and attack them? Well, under Arizona law, there's a statute for this. There's a statute called the Defense of Others Justification. And basically, you're allowed to use, in their defense, you're allowed to use as much force as is reasonably necessary that they could have used in that situation. In other words, and take kind of a prototypical example, you see an old woman being mugged and they have a gun to her head and they're trying to take her possessions and they're clearly threatening an imminent deadly physical force. In that situation, if she had a firearm, she would be justified in using it under the law, at least under kind of the prototypical circumstances that I just described. So if she is justified in using it, you're allowed to use as much physical force, including deadly physical force, as she would be justified to use. So in other words, if you see them posing an imminent deadly physical force to elderly neighbors or somebody else, the answer is yes. You are allowed to use a reasonable amount of force, and once again, the reasonableness of which will be determined by a randomly assembled jury of your peers. But you are allowed to use a reasonable amount of force, whatever they would have been justified in using in those circumstances. Let's keep going through some of the other aspects of this question. All right, so this is kind of an interesting aspect to this question, talking about mass vandalism, all right? They're burning down the whole neighborhood. I see this house is burned, this house is burnt, and it's getting dangerously close to my house. How much of that do I have to wait, and how much do I... Well, certainly, if they're burning down houses, this is more than just damage to property, right? Especially if there's an argument your family's inside, or you're not required to exit your house so that somebody has can at liberty burn it, right? So at that point, you definitely have a strong argument that use of deadly physical force is justified if they're talking about essentially trying to burn your family inside of the house. And I would argue strongly that use or display of deadly physical force at that point would be justified. Let me say something else about this, and this kind of goes to reasonableness too, this reasonableness analysis. Take a look back to the McCloskey case. Whether or not you think that their actions were legally justified, in other words, they were legally allowed to display the weapons in order to stop the physical force or the mob from throwing bricks or Molotov cocktails, I think we can all agree any competent gun owner that watches the video perhaps cringed a little bit at how the firearms were being handled, right? I think the video can kind of serve a dual purpose here to really be a call to action that if you're going to be a responsible gun owner and you're going to use firearms, it's important to be properly trained on them, such that you can use them in a competent manner. There's several clips of the videos where the firearms are perhaps not being held properly or kind of being pointed all over the place, and they're kind of at points kind of pointing the guns at one another or at the protesters with fingers on the trigger in an unsafe manner that might be used by a prosecutor, right, to say that their actions were unreasonable. Well, don't let a prosecutor argue that. If you've got, don't give them that freebie, in other words. This is just a matter of being competently trained on the firearm that you're going to possess. And people should be competently trained on their firearms. So if you put on your prosecutor hat and you are trying to, have that argument in front of the jury where you were trying to prove that the McCloskeys were unreasonable in their conduct, one thing that you might harp on and in fact try to kind of drive a truck through the point when you're presenting it to the jury is just look at how they were handling. They were recklessly pointing it with their fingers on the trigger. They pointed at each other. They were all over the place with it. She was holding it in kind of a weird fashion that suggested she didn't know how it worked or everything like that. I would use those types of things if I was a prosecutor to argue that these people did not act reasonably in that reasonableness analysis. So you could totally take the wind out of the prosecutor's sails on that front just by being competently trained in the use of your firearms. Now, there's a strong argument here that their display of a firearm objectively worked, right? It kept the mob from entering into their property. And who knows what would have happened if the mob would have followed through on their alleged threats and everything had they not displayed. So that's going to be their defense attorneys, in the event that they do get charged. That's going to be their defense attorney's best argument is take a look at this. Without this, who knows what would have happened? It was in fact successful what they did. So I think that's an important point to keep in mind, that competence in and training in the firearms, while just being a good idea in general, also has its place in the legal analysis, because it will be something that the prosecutor and the state will look very carefully at when trying to determine whether to charge you for unreasonable conduct. I think we've pretty much addressed all of the issues here, and certainly if you guys have any additional questions, you're welcome to email me directly. My email address is Andy, A-N-D-Y, @attorneysforfreedom.com, and I'd certainly be happy to answer any follow-up questions or any questions you may have about different scenarios. These are strange times for sure. And, it's even more important for responsible citizens and responsible gun owners to know their rights and have a good relationship with an attorney, so that in a worst case scenario, say for example the McCloskeys had to discharge their weapons, well at that point you don't want to be figuring out, who's your attorney and am I going to have a good relationship with a law firm that I trust from a jail cell, right, with the yellow pages, trying to figure out who to call and everything like that. So we appreciate all of our attorney on retainer clients and want you guys to feel that you can call us and reach out to us whenever you want. We are your resource. We are your team. We'd be happy to talk to you about any of these issues. Keep sending us your questions, by the way. We want to make this a regular thing where we take your questions from attorney on retainer clients, email them to us, and then we kind of do a long form discussion of those questions and record it in a video like this and send it to you guys as kind of some special content for you guys being attorney on retainer clients. I know that we're also planning on doing some kind of live webinars where we may broadcast via Facebook or some YouTube or something like that and make it only available to our attorney on retainer clients, discussions between myself and some of the other criminal defense attorneys at our law firm, such as Mark Victor, Howard Dorman, civil rights issues with Jody Broaddus, and other things like that. So we've got some exciting stuff coming up for you guys in the months to come. Don't hesitate to reach out if you ever need us. We're extremely easy to get a hold of. We return all phone calls same day, and we look forward to hearing you guys. Hopefully you'll never need us in an emergency, but absolutely you are justified as competent gun owners to use deadly physical force to defend your family and to defend your loved ones and other people from being injured by thugs, which is exactly what the questioner in this case kind of envisions and sums up in their question. So this has been Andy Marcantel. Once again, I'm a partner here on the criminal defense side for Attorneys for Freedom Law Firm. And it was a pleasure making this video for you guys today, and we look forward to hearing from you guys in the future. Stay well in these interesting times, and I hope you guys have a wonderful rest of your day.